This is the first in a series of 4 videos that we're going to do discussing the recent and very important changes in the rules that the VA adopted relating to eligibility for aid and attendance and other pension benefits. Those rules took effect on October the 18th of 2018. The first thing we're going to talk about is the difference in the asset rules. There was one change that is arguably beneficial. Before, there used to be a limit of $80,000 or less, and it was determined individually for each person that applied through something called an age analysis. Now there's a bright line limit. For 2018, it's $123,600. That's going to change annually because it's indexed to inflation. But an interesting thing about that limit is that although they call it an asset limit, they define assets as the combination of your assets, still, by the way, if you're married, they count both spouses, and your income. The VA still defines income in an odd way of subtracting out unreimbursed medical expenses. They've expanded the definition, but even if you have more medical expenses than income, you can't get below 0 on that. Your residence will remain an exempt asset, at least for most people. Now, the VA has a 2-acre limit with a few minor exceptions to that. Since we have a lot of clients who live outside the core urban area, that one sort of really disturbs me, because if you live in a $5 million mansion in New York City, your residence is exempt. If you live on a house in 10 acres out in the country, your residence may not be exempt and probably isn't. I'm going to sing the same song at the end of each of these. Whatever rules change and get more complicated, you need to be careful, and I would suggest to anybody who is looking into VA benefits would be very wise to consult with an experienced elder law attorney like us at Coulson Elder Law. Thanks.